Well, welcome everybody to the afternoon session on international law and domestic courts. We really appreciate your being here. I'm Cassandra Robertson, and I will be both the moderator and a panelist on this panel. To my right is Professor Laurie Blank, who is professor and director of the International Humanitarian Law Clinic at Emory University School of Law. And she'll be speaking first for about 15 minutes, and then we will hear from Stephen Schneebaum, who is on her right, who is a shareholder at Greenberg Traurig and who has extensive experience actually litigating international cases in domestic courts. So let's start with Laurie.
Great, thank you so much. See how this works. I'm very happy to be here, and I'll send my thanks to the other room, to Mike Scharf and everybody for putting on a great event and inviting me to be here. And I should also note that I think this is a first for me to be on a panel with a former professor of mine, so it's a real honor. I'm very glad that you could join us. Anyway, so our topic, we're going to have sort of an eclectic, I think, conversation today, and one of our panelists unfortunately had a tree fall in her house, and so that's why there's only 3 of us here. But I'm going to take a look at the issue of international law and domestic courts from one very discrete angle, which is the framework of the law of armed conflict or international humanitarian law, which are reasonably interchangeable terms, so I will use them today interchangeably, although we could quibble about the boundaries there. But in the last 10 years in particular, since the current paradigm of countries fighting against terrorist groups, transnational conflict in this setting, since this has really taken hold, we've seen an increased attention to how domestic national courts might look at questions that arise during wartime, national security crisis. It's not a new question. It's obviously been happening in this country since this country was founded, and obviously in other countries long before, and will continue to do so. But I want to highlight a couple of different questions here and look at this, I think, from more of a process angle rather than looking into specifically what courts say on these questions. And the reason for doing this is because this body of law, the law of armed conflict, is only applicable during armed conflict. It doesn't apply during peacetime. And so we have an initial threshold question that applies, that courts need to first address, which is, am I going to apply this law? Or am I going to determine that it's not am I going to ignore it? Am I going to determine that it's not the relevant law? And we also have another piece of the equation, which is that during, at least in this country in particular, during times of crisis, during wartime, similar situations, the courts tend to defer to the executive. So we see some interesting interplays here in how these issues might come up in domestic courts. So what I've looked at is raising some questions and issues about when and how courts are going to apply international humanitarian law. And in doing so, I think that these process questions end up being substantively determinative. And to me, they're important in 3 areas why this is important to look at to begin with. And one is litigation strategy, a second one is jurisprudential predictability, and a third one is looking sort of in a broader sense at the overall development of IHL. And these are sort of why we want to wonder about these questions beyond the results of a particular case. So as my colleague here could tell you a lot better, obviously when you're going into court and you are trying to decide what strategy to take, you need to understand how the court that you're dealing with may be looking at the law. You don't want to just look at what are the facts, what is the legal, what are the legal parameters that we're dealing with, did he do it, did he not, et cetera. But how does the court frame these issues? How do they take to these issues? Do they welcome international law as a source or not? Well, if they're going to be, somewhat opposed to the idea of incorporating international law, like some U.S. judges are, depends, obviously, then maybe that's not the best strategy. So that's sort of a strategic parameter. And jurisprudential predictability is also important because lower courts are going to want to get a sense of how the courts above them are going to look at these issues, because obviously they don't want to be overturned. They want to have a sense of continuity, and decision makers who are going to follow and have to abide by what courts do want to have a sense of predictability about how courts would treat the types of decisions that they're making. And finally, the question of how the law is developing. I think in this sense, when we have courts that choose not to engage with this body of law as much, we're going to see a more stunted development of the law. When we have courts that are keen to engage in these issues, then obviously we're going to see a richer process of grappling with tough legal questions and seeing how the law is going to develop. So in that sense, from my perspective, I think it's critically important that courts engage these issues so that we can continue to see the law develop over time and deal with the toughest issues of the day. So I'm just going to throw out, I guess, a bit of a framework for how I think we can look at what courts do and even what they should do on these types of cases. So the first is a threshold of analysis perspective, and looking at three different issues that are really a first look before getting into the nitty-gritty of how a court would actually deal with the questions at hand. And one is, what types of cases actually even pose these issues? So we have to really think about whether a court is going to get engaged to begin with. And there's three areas here that I want to raise. And one is the existence of a conflict. One is the type of conflict, and then another is sort of just listing some key issues that really seem to either engage courts or get courts to back off very fast. So with the existence of a conflict, this is a classic case where you see the executive and the courts tend to, in certain times, clash with each other, in effect. Because historically, countries, governments will say, well, we're not in conflict, so the law of war doesn't apply. You even see the U.S. saying this when we went into Panama in 1989, which is hard to imagine. We had 40,000 troops there. We were taking prisoners of war, et cetera, but the U.S. never acknowledged that we were in an armed conflict. We see this is, you know, there's lots and lots of examples. But from the point of view of international humanitarian law, the question of whether or not a conflict exists is an objective determination. It's not a political decision. That's why the Geneva Conventions don't use the word war. They use the term armed conflict. This is one where courts really have to first decide. They have to use international humanitarian law to determine if they're going to use international humanitarian law, basically. And we have some courts that will defer to the executive, and then we have other courts that will tend to take the executive on and make a determination essentially right in the face of an executive determination that there's no armed conflict going on and this law doesn't apply. Some courts will actually come to the opposite conclusion. This naturally has a huge impact on then what happens going forward in the case. Going forward, we can look at some of the Guantanamo litigation, for example. The U.S. government, particularly the previous administration, argued that the Geneva Conventions didn't apply to our conflict with al-Qaeda, to what was going on at Guantanamo. Over time, as the cases made their way through the courts, and ultimately with the Hamdan case, the Supreme Court held, no, that's not right. The Geneva Conventions do apply. They looked at that. That changes automatically so many questions going forward in the litigation going forward. Another question that stems right from there is what type of conflict. So once we find that there is a conflict, then it's a question of which parts of IHL are going to apply. Is it an international armed conflict where the full body of law applies? Is it a non-international armed conflict? The Hamdan case is another example of this, where we can look at what our U.S. Supreme Court found. It's a non-international armed conflict that then has ramifications for things like, well, there would be no prisoner of war status in a non-international armed conflict. You look at what the Israeli Supreme Court says about its conflict with terrorist groups outside its borders, Hamas in Gaza, Hezbollah in Lebanon, and it calls that an international armed conflict. That changes how they're going to apply certain facets of the law going forward. Another area here in this threshold analysis is just key issues that are almost like push buttons for courts. So a classic example here is targeting. Questions will come up about the targeting, destruction of enemy property during wartime. And in general, the executive says, hey, this is our bailiwick. You know, courts, you can't get involved here. We get to determine who the enemy is and who we're going to target. And classic case there we have is the El Shifa case, where back in 1998, when then President Clinton ordered the cruise missile attack on the chemical plant in the Sudan, which some argued was a baby formula making plant, and that went to through the court system for damages, and the court deferred. I mean, the court essentially gave deference to the executive and said, we don't get involved in targeting. It's a political question. Other questions, other issues, courts are going to find that they want to play a role. And there's a couple of issues, I'll just list some, other issues here that will have an immediate sort of strategic role to play in how we look at a court. We'll look at these issues, and one would be conditions of detention. So this is obviously something where you would think a court would get very involved. But we recently see here in the US a great reluctance until, I would say, this year for courts to get involved in cases dealing with claims about torture and other violations of the law, conditions of detention at Guantanamo against US politicians, Rumsfeld and et cetera. A couple of other issues would be detention generally, trial, status of persons, are they combatants, are they civilians, who are they, and then just definitions. What does torture mean? What does enemy combatant mean? And we see courts actually engaging in a definitional process in some of these cases. Just to move on, once we go beyond this threshold analysis, I think there are some interesting factors to look at about when courts might decide to engage with IHL questions. And here I highlight a couple of factors, which is, first of all, the suitability. How suitable is IHL as a legal regime that the court would look at it as a suitable legal paradigm for the issues it has before us? The obvious example is there a conflict? Well, sure, that's one where IHL provides a lot of guidance. There are other issues, even such things as detention in non-international armed conflict, where courts are going to find human rights law and domestic law and lots of other legal regimes also useful, and we might see some kind of grappling with, well, which one do we want to choose? And some courts are more comfortable with one versus the other. Another one might be the challenges of applying the law here. How hard is it going to be for a court to figure out the law of war issues involved? And we sometimes see that courts will back off almost if there's an easier answer to be found somewhere else. Another one is, what are the comparable domestic law principles? And will the court find greater ease or comfort or just a natural inclination to look to those? And also, what other legal regimes and how do they interrelate? And then finally, there are some factors relating to how a court might decide to apply the law of war, and once they do. And this, we can look generally at how a country approaches international law in its relation to domestic law. Is international law automatically part of domestic law? Do we have to look at whether treaties are self-executing? Is it separate? How do courts view international law as a precedent for them? Another factor is, how do courts look at customary law? Are they comfortable with customary international law? And I think my colleague here will talk a lot about the Alien Tort Statute cases, and there we see questions about whether courts want to explore the content of customary international law. Do they want to dive into that, figure out what customary law is, because if you're going to use it as a source, you have to understand the content of it. And sometimes some courts are more or less comfortable with that. And a final question would be looking at comparative jurisprudence, regional jurisprudence, international jurisprudence. You look at courts in Europe, they have a binding higher judicial authority in the European Court of Human Rights whose precedent they have to follow and whose precedent guides their type of decision making. That's going to change greatly how they choose to incorporate the law of war and incorporate human rights law into their decision making process. So I'll just sum up quickly by saying that I think all of these factors really come into play in understanding how IHL is going to be implemented in the courts and what effect that's going to have on the development of the law going forward. So, thank you.
Great. Thank you very much. Okay, I think our next speaker is going to take us more towards the Alien Tort Claims Act and looking at some of those cases in domestic courts in particular.
Well, good afternoon, everyone. And Michael, glad you're here because everybody has been thanking you in absentia, and I get to do it in person, which is much better. I got to say, having now following Laurie, one of the great pleasures that one has as one gets older, not that I would know, but I'm speculating, is you get to see your own kids grow up. That's pretty terrific. But you get to see former students of yours or former associates in your law firm going on to great things. Justice Goldstone spoke earlier about the head of the appellate body at the WTO, Jennifer Hillman. Jennifer Hillman was an associate of mine many years ago. Rob Portman, your new senator from Ohio, was an associate several years ago. But nothing quite beats the pleasure of watching a former student being expert. And so, Laurie, I'm so glad you invited me to come and participate. This is fun. I want to talk about a trend. I don't know that it rises to the level of crisis, but a trend that we are seeing in U.S. courtrooms concerning the use of international law. And I start from the premise that with the increasing internationalization of virtually all aspects of our lives, from obvious examples such as technology to perhaps less obvious ones, international law influences all of legal practice, from environmental law to tax to family law. Everything that we do is likely to have some international dimension. And international law in law schools and in practice is being treated less and less like a specialty and more like an aspect of the practice of law that we just have to internalize. The way civil procedure is an aspect of the practice of law that we have to internalize. At the same time that's happening, though, there is resistance. There is resistance to the incorporation of international law in domestic courts, and there is resistance in the use of international legal sources as actually having something important to say. And I think if there is a crisis in international law in courtrooms, it comes from that. I'm not sure that there is, but if there is, it comes from that. There has been this kind of resistance. And I want to describe briefly 4 instances of resistance to the incorporation of international law into the kind of law that's actually applied by real judges in real cases in real courtrooms. The first 3 I will list now and then explain them. I'll get to the 4th at the end of my talk. The first 3 are imperialism, indeterminacy, and inefficiency. It seems to me that there are objections to the use of international law, including objections coming from very learned sources. Not talking about, yahoos now. We're talking about people who wear black robes. I guess some of them may be yahoos, but anyway, we'll ignore that for the moment. The resistance is often based, let's start with the first one, on the notion that somehow for the United States to hear a case that arose overseas alleging, say, that in an example that I cite in my written remarks, an Indonesian general gave orders to massacre innocent civilians in East Timor in 1999 as the Indonesians were leaving the island, and decided that basically they were going to destroy everything made by humans so that nothing would be left behind, and a large number of people were killed. There was an Alien Tort Statute case brought in the District of Columbia. I represented the plaintiffs, along with others, and we found the general, and we sued him, and we brought before a U.S. district judge for the District of Columbia evidence concerning things that had happened literally on the opposite side of the planet years before. And there is a sense, at least on the part of some people, that invoking the Alien Tort Statute or anything like it with respect to events that happened so far away among foreigners is somehow engrafting U.S. law. It's an imperialistic invasion by the United States of the place where these events occurred. So that is one type of objection. My view is that that objection is wrong-headed, and it's wrong-headed because it is confused with an issue that is, to me at least, analytically very different, and that is the question of universal jurisdiction. Some of you will have heard the panel on that topic this morning. It was interesting to me that in the discussion of the Eichmann case this morning and the discussion of universal jurisdiction, no mention was made of the only case I know of, at least, in which universal jurisdiction was explicitly cited as the basis for decision in a U.S. court. And interestingly enough, that case happened right here in Cleveland in 1985. It was the case of John Demyanyuk. You may remember him. He was the Ukrainian who lived somewhere near Cleveland, who was determined by the Israelis sometime in the early 1980s to have been, or at least there was credible evidence to believe that he had been a guard and worse at Treblinka and Sobibor, and that he was responsible personally for the murders of a large number of Jews during the war. Demyanyuk was stripped of his citizenship through a normal denaturalization procedure, but at the end of that procedure, the Israelis then filed an extradition request seeking to have him extradited to Israel to stand trial there under the Nazis and Nazi Collaborators Act, which is the act that criminalizes, among other things, crimes against humanity, crimes against the Jewish people, and that sort of thing. The federal judge who received that petition here in Cleveland, Judge Battisti, put out an all-points bulletin to human rights organizations to come advise me, because he said, look, these crimes that he's accused of were committed outside the state of Israel before it came into existence as a state. Can you do that? I mean, if I extradite him, I am submitting him to Israeli jurisdiction when, in fact, there may not be such jurisdiction, so I need help. Various human rights groups answered. One whose board I was on answered, and Judge Battisti invited me to come to Cleveland and do oral argument in that case, which I did. The only time in my life my picture has been drawn by a courtroom artist. You know, it was that big a deal. It was on the first page of the Plain Dealer the next day. In any event, in that case, Judge Battisti held that it was consistent with international law for Israel to try Demyanyuk. Of course, whether he was guilty or not is another story, but it was consistent with international law to put him on trial in Israel, and therefore he signed the extradition warrant. The Sixth Circuit upheld the decision, and some of you may know the rest of the story. He was extradited, he was put on trial, he was convicted, sentenced to death, and after he was sentenced in Israel, it was determined that some of the evidence on the basis of which the conviction was obtained was suspect. It may have been forged. It may have been Soviet forgeries. And so he ended up coming back to the United States and just recently was sent to Germany to stand trial in Munich, I believe, and that trial is ongoing. He's 90-something years old at the moment. But in any event, that is an illustration, I think, that there's nothing imperialistic about the United States courts saying what the law is. That's what judges do. That's what they get paid for. And, you know, you all know Marbury v. Madison, right? Chief Justice Marshall said, it is the province of the judiciary to say what the law is. And it has been clear since the foundation of this country, and certainly clear since the famous Paquete Habana decision in 1900, that international law is part of our law. So for judges to say what international law is simply for them to do what they get paid for. That's their job. Now, it's interesting, though, that the charge of imperialism seems to be based on the notion that, left to its own devices, Paraguay would happily go about torturing Joelito Filartiga to death, and there's nothing wrong with that. Well, there is something wrong with that. There is something wrong under Paraguayan law. There's something wrong under binding notions of international law, treaties to which Paraguay is a party, and so is the United States. And, of course, there's something wrong under customary law, every bit as much a source of law as treaty is. So there's nothing, I would submit, imperialistic about the United States hearing tort cases alleging misconduct in other countries. After all, we do it all the time. The tort follows the tortfeasor. Remember that old principle? You can serve the tortfeasor wherever you can find him. What's the difference between a tortfeasor who committed torture in Paraguay and a tortfeasor who negligently banged his car into mine in Windsor, Ontario? And certainly nobody would object to that case being heard in Detroit. Happens all the time. The tort follows the tortfeasor. So there's nothing, I submit, imperialistic about it. Now, the next allegation, the next charge, if you like, is indeterminacy. And that, I guess I've just alluded to how that argument develops. That is the case that, the sense that international law is it's very hard to find, for one thing. There's no statute book, there's no legislature, there's no authoritative interpreter of international law. It's a moving target, it's nailing Jello to the tree, it's whatever your favorite metaphor is. That makes it hard, but it doesn't make it something outside the jurisdiction of the courts. Courts have to decide hard cases all the time. And that's again, that's their job. Now, in the case before the Supreme Court, Sosa against Alvarez Machain, the only case to date, there's another one coming, but the only case to date in which the Supreme Court has interpreted the Alien Tort Statute and said what it means, in that case, Justice Scalia, who of course is one of the more resistant of the justices to the idea of international law having anything to say to U.S. courts, was questioning Paul Hoffman, who argued on behalf of Dr. Alvarez Machain. And Paul was explaining to the court that the Alien Tort Statute says that federal courts have original jurisdiction of violations, of torts committed in violation of the law of nations. That requires some digging into what the law of nations is, but that's nothing outside the normal judicial function. Justice Scalia interrupted him and he said, "The problem I have with your proposal is that it leaves it up to the courts to decide what the law of nations is." Now, I don't understand that. He's a strict constructionist. Of course it's up to the courts to say what the law of nations is. Who else would we have say what the law of nations is? So, yes, there is a problem of indeterminacy. Yes, there is a problem in international law that there are lots of sources out there. There are lots of journals in which learned articles are written, maybe even by people like us. And you can, as Chief Justice Roberts recently said in a public forum, you can find international law that will support almost any proposition. But good lawyers get paid to support almost any proposition. There's nothing unique to international law about that. The third set of accusations is inefficiency. That is, why are we using judicial resources to sort out a claim between East Timorese plaintiffs and an Indonesian general? What sense does that make to do that in Washington, D.C.? It's a waste of money, waste of resources. Again, to quote Paul Hoffman, Paul has tried a lot of ATS cases, and he refers to what he calls the blank stare response that he gets from judges when he brings these cases in, and they look at him like, what? Again, my article is called, "What is this case doing here?" And that's the response you get. But inefficiency is a problem for courts in general. And I would submit that there's nothing uniquely inefficient about international litigation. Indeed, I just came back from a jury trial last week in San Francisco. Commercial case, nothing to do with what we're talking about here. Just a dispute between two companies about $23 million. And in order to sort that case out, I had to persuade the jury about what people meant by certain things that they said and did. And the other side tried to persuade the jury, wrongly of course, that these nasty things that were done were actually quite innocent and in fact well-intentioned. So the jury has to infer facts from evidence. They have to stitch together retroactively a picture of what happened. It's tough work, and it's inefficient, except it's better than all the alternatives. So yes, it's hard to find evidence of what happened in East Timor, but we have doctrines to deal with situations like that. We have the doctrine of forum non conveniens, for example, in which jurisdiction can be declined in situations in which there's a better forum to try the case. We have doctrines like the political question doctrine, or active state, or even, after the use of the Samantar case of last term, the doctrine of sovereign immunity. There are lots of ways that cases that don't belong in US courts can be coaxed out of them, leaving behind those that are properly within the scope of the Alien Tort Statute or any of the other statutory instruments that import international law into our courtroom. So those are the three principal bases for judicial resistance, I submit, to the use of international law. I don't know, again, whether this has reached crisis proportion. Certainly, the alien tort cases are alive and well, many of them percolating through the courts as we speak. The big issue now, for those of you who are interested in this area, the big issue that the Supreme Court will have to decide is the question of potential corporate liability for violations of international law. When does a corporation become responsible as a defendant? And that leads to the question, when, if ever, is a corporation a subject of international law? Those questions are being decided by courts. Damages are being awarded. Damages are even being collected in ATS cases all the time. But there's another source of resistance, and this doesn't come from judges. This comes from the street. Let me read you this. This bill that I'm about to read was presented in referendum to the voters of the state of Oklahoma in 2010. The courts provided for elsewhere in this Constitution, this is to be a constitutional amendment, the courts provided for elsewhere in this Constitution, when exercising their judicial authority, shall uphold and adhere to the law as provided in the United States Constitution, the Oklahoma Constitution, the United States Code, federal regulations promulgated pursuant thereto, established common law, the Oklahoma statutes, and rules promulgated pursuant thereto, and if necessary, the law of another state of the United States. The courts shall not look to the legal precepts of other nations or cultures. Specifically, the courts shall not consider international law. Now, it also says international or Sharia law. I'm not going to put that red herring in front of you now. But the courts shall not consider international law. The statute was immediately tossed out by a federal judge in Tulsa, and it will remain tossed. It is unconstitutional on its face. But imagine that. What we have here is the sense that why international law is to be resisted is not that it's imperialistic, not that it's indeterminate, and not that it's inefficient, but it's foreign. And that's all you need to know. It didn't come from here. And there is something inherently wrong in the view of the proponents of such things as this. Something inherently wrong with having judicial officers sworn to uphold the Constitution and the law deciding cases based on something like this, something we don't understand, something that was not created here. Well, that is a fundamental difference in views, of course, between those who see international law as part of our law and those who see it as something to be engrafted onto our law, a foreign body to be engrafted onto our law. I think the best I can do is end with this notion that the idea that the United States would take its place in the community of nations is an idea as old as 1776. Indeed, you know, as you all know, the Declaration of Independence, Thomas Jefferson says, one of the reasons for writing the Declaration, instead of just, you know, stomping out and starting a revolution against British rule, one of the reasons for putting these thoughts on paper was to be candid with the rest of the world out of a decent respect for the opinions of mankind. That engages the United States as a participant in the world and engages the world as an influence on our jurisprudence in this country. It seems to me that the position to the contrary, the position taken by the Oklahoma Amendment and by the statutes that are introduced every year in Congress for the last 10 years or so that would accomplish the same sort of thing, they are the radicals. That is not in keeping with our American traditions. The statute, incidentally, the amendment in Oklahoma was called, the popular name was the Save Our State Amendment. So we need to save the state of Oklahoma from the insidious wiles of such international lawyers as Michael Scharf. And if we don't do that, we risk losing something. Well, my submission to you is, if we do that, we risk losing something. Thanks.
Thank you very much. Okay, so we've heard some of the substantive issues that are going on in international litigation with the International Humanitarian Law in litigation and Alien Tort Claims Act cases. My topic today is going to be about an issue that really crosses substantive areas in international litigation, but it's the growing trend of third-party financing on transnational disputes. Litigation finance is very similar in some ways to the American system of contingency fees, where you have a person putting up the expense of the litigation. It gets different though. In American-style contingency fees, it is the litigating lawyer who is forwarding the expenses of litigation in exchange for, say, a 30% stake in the outcome. The difference is that in the growing third-party financing, it truly is a third party. It's often an insurance company or a large financial company, Citibank, for example, would be putting forward the costs, and often not just the litigation costs, but also simply forwarding funds to the plaintiff that can be used for whatever the plaintiff needs, whether that's living expenses or anything else. So in the last decade, this has been growing tremendously globally. It really got its start in Australia, which had the first very developed market, and the High Court of Australia signed off on it a few years ago. It's grown very quickly thereafter. There was also legislation, in the jurisdiction of England and Wales that got rid of the old restrictions on what had been called champerty and maintenance, and made it possible for companies to provide litigation funding to litigants. In the United States, it's also been growing. About half of US states now allow third-party financing of lawsuits. And that's a growing number. You're seeing lobbying efforts even in the states that have not traditionally permitted it. And because the United States is a big jurisdiction, generally the market, even though it's only allowed in about half the states, the market is about $1 billion market annually. So this is growing. Now, typically in these countries, what you've primarily seen is litigation funding that supports domestic litigation. So in Australia, the majority of the financing goes to fund commercial disputes that are simply domestic Australian disputes between businesses. In the United States, it's historically been personal injury litigation. This is starting to change a bit, though, and we're seeing some of the bigger financing companies seeking out transnational litigation and other opportunities to grow and expand their business. I know a number of you are familiar with the Chevron Texaco lawsuit arising out of the Ecuadorian Amazonian litigation. And this is one of the big cases that has been highly publicized. A company called Burford Capital, which is one of the big English companies that provides financing, put forward $4 million into the Ecuadorian litigation. The Ecuadorian litigation, for those of you who are less familiar with it, it started in the United States back in the 90s. The case was filed against, at that time, Texaco, and it was brought by plaintiffs who were indigenous residents of the Amazon who alleged that they had been harmed, either physically injured or suffering from problems arising out of environmental degradation due to oil contamination in the Amazon. So the case was filed first in New York. In the early 90s, the case was dismissed under the doctrine of forum nonconvenience. Typically, a forum nonconvenience dismissal in the past represented a win for the defendants because plaintiffs were not usually able to then refile those cases abroad. In this case, though, we saw a couple of different trends converging. One of those was that the Latin American countries had been objecting to forum nonconvenience dismissals and had been enacting legislation to make it easier for those cases to be refiled in Latin American countries. And then, of course, the other part of it was that a big part of the reason that litigation doesn't often get refiled abroad is because the plaintiffs can't afford to bring it. Contingency fees are available in the United States very easily. They historically have not been available in other countries. And so without some mechanism for funding the litigation, it often couldn't be refiled. Here, you had US plaintiffs' attorneys putting money into the case and then also substantial resources from Burford Capital. So they invested $4 million in the case against Chevron in exchange for a 1.5% stake in whatever the outcome would be, and planned to increase that then to putting in $15 million into the case in exchange for a 5.5% share. So the case did go forward in Ecuador, and the Ecuadorian court awarded an $18 billion judgment, which was the largest judgment ever in an environmental case to this date. So there's a very large judgment outstanding, but the case is certainly not final. Chevron is vociferously objecting to judgment enforcement in the United States. And the case has been extremely controversial with allegations of fraud on both sides and a lot of drama and controversy. In fact, some of the drama is the reason why we even know about this financing agreement. Typically, these third-party financing agreements are kept confidential and we don't hear about them. In this case, there was a documentary film being made about the litigation, and the filmmaker was very sympathetic to the plaintiffs. The plaintiff's attorney agreed to spend a lot of time on film talking about the case. During some of that time he was being filmed, he talked about the financing agreement with Burford Capital. Turns out he waived privilege on that by talking about it on film, which is how we now are able to see the financing agreement there. But what does this mean for other cases? I think when we've really seen the development of the market to such a degree, especially in Australia, England, and the United States, very large and often publicly traded companies are the ones making these financing arrangements, these investments. These are companies that are very comfortable operating on a global scale, and I think they're looking for opportunities to expand. There's a number of other countries that have absolutely no restrictions on litigation financing, although they do not have developed markets for it on their own, and this is a lot of the civil law countries. So countries such as Spain, Brazil, Mexico, Argentina, Bulgaria, et cetera, have been identified as places with absolutely no restrictions that might provide a market for some of these financing companies to move into. So the impact on transnational litigation, I think most people agree it's probably going to increase the number of lawsuits filed. More plaintiffs will be able to afford to bring suit when they no longer have to have resources to file the case. They can get those from the funding company, who will then recover costs on the back end. So it will probably increase the total number of lawsuits filed. It will probably increase the settlement value of a lot of those claims. For plaintiffs who could perhaps have filed in the past but might have felt pressured to settle quickly, they may be able to hold out for longer because they don't need immediate living expenses if they have funding from an outside party. And also the presence of more parties in the marketplace who can bid on these claims essentially is likely to run up the price or the settlement value of these cases. There's very little incentive really for third parties to invest in fully frivolous litigation because these are non-recourse investments. If the plaintiffs don't win or settle the case, then the investors get nothing under the agreements. But there is incentive to invest in very high-profile, high-dollar award cases, even with a small chance of ultimate recovery. So even a small percentage chance of ultimately recovering in the Ecuadorian litigation, for example, may be worth the investment if the potential outcome could be $18 billion or 5% of $18 billion. So given the enormousness of that judgment, investment in the claim may very well be warranted, even with a low probability of ultimate judgment enforcement. The other thing I think that might be affected here is a shifting magnetic polarity. The United States has traditionally been called a magnet forum for transnational litigation. A big part of this, right, was the availability of contingency fees here, which weren't usually available elsewhere. This may shift to a degree. I think the United States will stay a magnet forum for other reasons. The United States has much broader discovery rules, which it tends to be favorable to plaintiffs, and finally, much higher damage awards and availability of punitive damages in a lot of cases, which I think is probably the most important magnetizing factor. But I think that we will see some shift in those cases that are dismissed on forum nonconvenience or otherwise. Right now, there are really quite a large number of cases being dismissed on forum nonconvenience grounds. Historically, those have very rarely gone forward. With outside financing, you might see plaintiffs choosing to pursue a higher percentage of those cases in other locations, probably in the plaintiff's home forums. Many of the cases that are dismissed under the doctrine of forum nonconvenience are cases brought by foreign plaintiffs against U.S. corporations. So, historically, the U.S. defendants have had a strategy of trying to get them dismissed from the United States and considering it a win once it is. I think it's going to be more difficult now because I think that other countries are going to welcome those cases with open arms as long as the plaintiffs can afford to bring them in their home forums. When the plaintiffs are resident nationals and the defendants are non-resident national U.S. corporations, I think you will see those cases being welcomed into other jurisdictions and perhaps a diffusion of transnational cases. They won't just be centered in the United States anymore. Finally, I think that we will see some social and regulatory impact from an increase in litigation. I think it's very hard to predict what this might look like. Some scholars have suggested that increasing global litigation rates may increase product safety for what are called global goods, goods that are sold worldwide. Tires are a good example. Sold all over the world, same product. Historically, some law and economic scholars have said when litigation levels were very low outside the United States, higher inside the United States, those companies had an easier time internalizing some of the costs of injuries that were caused. They could afford to pay more for the injuries that happened in the United States when litigation was rarely occurring for the injuries that happened outside the United States. I think if we see a worldwide increase in litigation, that will affect those manufacturers, and it is possible that that will lead to an increase in product safety, probably also along with a marginal increase, at least, in cost. Other possible outcomes, I think countries might reassess their balance of regulation and litigation when they see litigation rates increase. Every country has its own equilibrium of regulation and litigation. In the United States, we have tended to tilt much more highly towards the litigation side of that, and that has been different in other countries. And I think seeing an increase in litigation will lead to countries reassessing that balance, and again, they could reassess it in either direction, either welcoming more litigation or taking efforts to make litigation a bit more difficult and putting more emphasis on the regulatory side. My hope is that we might also see greater international cooperation in this area, potentially both on substantive regulatory issues and possibly also on issues of litigation procedure. I think it would be nice if this led to renewed negotiations for a cross-border judgment enforcement convention. There's obviously been efforts at The Hague for such coordination. So far, the Judgment Enforcement Convention failed. They had a less ambitious choice of court convention passed in its stead. But a more globalized network of litigation and investment in litigation might speed up the pace of those negotiations. So just in conclusion, I think third-party litigation finance is a very rapidly growing industry and a very large industry that is going to continue growing worldwide. It's very hard to know what that's going to change, but I think in all likelihood it will increase the number of transnational lawsuits filed and probably increase the settlement value of those suits. And it may also spread those suits out among a larger number of countries than we've seen in the past. Hopefully, we will also see greater international cooperation in that area. Thank you. All right, we have a few minutes if anybody has questions. Sure, Becca?
I was wondering, in terms of the third-party financing, if that has a tendency to increase the cost of services amongst lawyers, because if you're getting an unlimited amount of money or a seemingly unlimited amount of money, you can charge more for your services. I was just wondering what effect that would have.
I think it could. I think we haven't seen the market get saturated enough at this point that we've seen a real increase in the fees that attorneys charge and their hourly billing rates. But if it continues to grow, I think it definitely could.
Good afternoon. It's all been informative. And my name is Rich Olavito, and my question is directed probably to the first presenter and then her mentor. I worked in the field of, in Ohio particularly, but in the Midwest on human rights, civil rights issues, the complex field of police misconduct. And one of the things that I was involved in was the United States Justice Department Special Litigation Unit, so pattern and practice investigations. And in that investigation, there was a landmark case, was in Steubenville, Ohio, not a few hours away. And in light of that work, it rose to the top of Amnesty International and some other human rights groups. And later on, 5 or 6 years later, we got involved again in Warren, Ohio, through a mediaized case that made national attention. In both instances, we brought the Justice Department into the case, and what I've asked the question is going to be, it gets to, when I litigated the second round through the Civil Rights Statutes of the 1983 statute, I also appended the international law appeal, because of what happened in the pattern and practice events and how the Justice Department. I'm just real curious. Of course, I don't know how to define the federal judge's response other than it lasted about a summer afternoon. It didn't last too long, and the judge took it. I'm curious. I just want to see if Going back sort of not from East Timor to the United States, from the United States, downtown Warren, Ohio, when we have 1,000 people violated by having 15-year-olds strip searched to nakedness in broad daylight and police admitting to doing that, is that not an international, or could that be an international issue?
Yes. Next question. No. Yes, certainly there are international implications of something like that. Although, as you know, the United States, in its adherence to the important international human rights treaties, like the ICCPR, for example, always has a reservation that the treaty is not self-executing, and therefore, presumably, it can't be the basis, it can't be the sole basis for a challenge to government action. But it can be one of the bases. It can be coloration that explains the magnitude of the offense. And it's interesting that those who are strongest in their resistance to the use of international law in US courts always recent years, point to two cases. They point to Lawrence v. Texas, the case in which the Supreme Court overturned its earlier decision of just a decade before, saying that states may not forbid private consensual homosexual conduct, and also Roper v. Simmons, the case that finally excluded the juvenile death penalty. In both of those cases, the Supreme Court found support for its view that there was an emerging sort of moral sense around the world that, in the first case, that what people do behind closed bedroom doors with consenting adult partners is none of anybody else's business, and in the second instance that the definition of such vague terms as cruel and unusual punishment must take into account developments not only within the 50 United States, but around the world. And there's been a lot of pushback on that. But I think the lesson we can take from it, until those two decisions are overturned, the lesson we can take from it is that it is helpful in presenting contextual argument to provide judges with this kind of information. I had a juvenile death penalty case a couple of years before the Supreme Court threw out the penalty. Unfortunately, my client was a couple of years too early and was executed. But in that case, I made the argument in every court I was in that, by the way, in addition to everything else, part of the demonstration that executing juveniles is by definition cruel and unusual punishment is that there were at that time only 5 countries in the world that admitted that they executed people who committed crimes before their 18th birthdays. And they were, interestingly enough, Iran, Iraq, Yemen, Nigeria, and the United States of America. In the entire decade of the 1990s, they are the only countries on record as having done that. In the first 2 weeks of the year 2000, the Commonwealth of Virginia alone executed 2 juveniles. But my point is, before the Supreme Court, in a landmark decision, finally agreed with what I was arguing, that argument just drew no resonance at all. Not a question from the bench during oral argument, not a comment in the written opinions, nothing. It's as if it wasn't there. But, you know, to some extent it's water dripping on stone. Ultimately, when the juvenile death penalty was thrown out, Justice Kennedy found support in the notion that no civilized country in the world executes juveniles. So it's helpful to make those arguments, and even if it might make only a marginal difference in this case or in that case, the notion that lawyers are going to be doing this more often can only have the effect of sensitizing the judiciary to the importance of international law. That's a good thing. Obviously, as a lawyer, your obligation is to your client, not to some cause. But all things being equal, it's a good thing, and you should do it.
I would just add, I think this raises another question as well, which is what is the difference between a court reaching a conclusion that a particular conduct violates the law based solely on domestic law or based on a combination of domestic law and international law. So we have plenty of law here that you can rely on without international
Sure.
law for human rights violations. We have it with violations of the law of armed conflict. I mean, our Uniform Code of Military Justice we prosecute soldiers for war crimes. We just don't call them war crimes. When you prosecutions under the UCMJ, it'll be for murder or this or that. It's like a common law crime as opposed to the big sounding crimes against humanity, et cetera. What's the difference? Does it have a change? Well, I think there's a good argument to be made that if you get somebody for murder rather than war crimes, they're still going to get the same punishment. They're still being punished for it. It doesn't maybe have the same effect on the broader sense, like on the street or outside our boundaries. The same thing with the value of incorporating international human rights law into a case like the one that you're talking about. It gives it a broader perspective. Does it change anything with regard to that person or the people you're trying to protect their rights? Not really in the immediate factual sense, but it has a broader impact.
If I may. Quickly, two things on that, just a follow-up. One, I'd like for you to become the federal judge on. Second of all would be, maybe we can get that recognized. The one thing that's unique about that law, and the reason why I was using that to the courts was that's the only law on the books that allows the Justice Department to go after pattern and practice, and it's the only law in the country, and it's a developing area of the law, and they are finding these patterns. So, and then, real quick, the U.S. Justice Department itself went to Geneva and said the reason why we're fulfilling our obligations to the Torture Committee and our treaty is because we're finding these patterns in the police departments, and I think that makes an argument. I just didn't get the federal judge. I need you guys on the bench.
Hi, my name is Julian Koo. I'm a professor at Hofstra University, and I can't help myself. I wanted to push back a little bit on some of the arguments made or the views stated, just on a couple things. I don't disagree totally, but with respect to Stephen's characterization, I sort of only agree with 1/4 of the critique, I think, at least totally with respect to, I agree like something like the Oklahoma constitutional amendment is it definitely reflects some misunderstandings, and it's probably not very positive sentiments and not very accurate sentiments about the scope of international law and foreign law. But I'm not sure it's fair to lump, say, Justice Scalia and other critics, like I would count myself as one, of the use of international law in domestic courts in that same group. I'm not sure you were, but just to make sure that, because I would say that I would characterize if I may group myself with him, or his views, as really based on a domestic separation of powers concerns. So, for example, your argument, well, courts, of course, they should interpret the law of nations. Who else? But I'm not sure this is quite so simple. If you read the Constitution, the courts don't have explicit textual authority to interpret the law of nations, but one institution does have the power to incorporate the law of nations. It's Congress. The Congress is authorized to define and punish the law of nations under Article 1. And I don't say that the argument is necessarily clean or it's been settled. The point is that the view that I'm pretty sure Justice Scalia has taken with respect to international law is really a separation of powers critique, which is consistent with his critique of other types of law, really, constitutional law included, that it would authorize judges to give them too much discretion to develop the law in ways that are not accountable, or at least not sufficiently accountable, to legislative and other political actors. And that would place him in distinction. He's not someone, for instance, who doesn't believe in using international law. If you read his many decisions interpreting treaties, he freely cites foreign court decisions, international tribunals, in cases where he believes it's appropriate, and he's also used international law principles, customary principles in some of his decisions as well. So, I mean, I want to sort of just clarify that point, because I think that that's a legitimate, to me, and a persuasive critique of some of the ATS litigation, and even some of the other types of litigation, that it's not sufficiently authorized by our legal system, and there are other mechanisms which could incorporate international law. I don't mean to go on, but I know we have a little time. So, for instance, a good example of which is the Uniform Code of Military Justice isn't always thought of this way, but it is an implementation of American obligations under international law, and substantially more effective, in my view, than simply adopting the Geneva Conventions and then telling the judges to go at it. So I was wondering, the same view I would have, the Torture Victim Protection Act is substantially superior, in my view, to the Alien Tort Statute, because Congress has been involved and has explicitly authorized and defined the nature of remedies under international law. So I was curious whether any of you had sort of reaction to that critique and what your reaction to it was. Thanks.
Sure. I don't think that if Justice Scalia were a resident of the state of Oklahoma, he would have voted in favor of that amendment. Okay, so I was not attempting to weld together that kind of level of ignorance with his constitutional position. But I guess I would respond in two ways. First, the position that Justice Scalia takes with respect to separation of powers, legitimate constitutional interpretation, was on the losing end of Sosa v. Alvarez-Machain. That was precisely the argument that he made in dissent in that case, and it was a dissent. So maybe someday there'll be a majority behind the view that when Congress incorporates the term the law of nations into a statute, as it did in the Alien Tort Statute, that somehow that means that unless and until Congress provides additional content to that incorporation, the courts can't do anything with it. Again, that was the argument that the other side made in Alvarez-Machain, and Justice Souter rejected that argument, and so did a majority of his colleagues. But a better example, I think, even than Sosa, is what happened in the Paquete Habana case itself. Paquete Habana was a case that came out of the Spanish-American War. At the beginning of the war, President McKinley issued a proclamation, a presidential proclamation, dealing with a whole bunch of stuff that the people of the country would need to know during the war that had just been declared. And one of the provisions of that proclamation was that the law of prize would apply during the war, subject to the normal interpretations of international law. He explicitly incorporated international law, so described, as the guide for interpretation. Okay, so then some privateers are out off the coast of South Florida, and they pick up a Cuban fishing vessel in international waters, and they arrest it and bring it to the Key West, I think it was, as prize. And the question was whether the traditional international law of prize, which specifically excluded fishing vessels, whether that would apply in this instance. And the Supreme Court held, that President McKinley's incorporation of international law was sufficiently precise to allow the courts to make the decision. And the courts could conclude, and did conclude, that the international law of prize did not permit the taking of fishing vessels, and therefore the vessel was released from arrest. When, in other words, certainly Congress has the authority to define and punish, not to interpret, but to define and punish offenses against the law of nations. That's what the Constitution actually says. But when the executive branch in its province, or when Congress in its legislative activity, incorporates terms like the law of nations or international law or anything like that, only the courts can interpret that in exactly the same way that when Congress uses terms like adequate remedy or something, the courts have to say what that means. That's their job. That's all I meant.
Great. Well, if there's no other questions, actually, I'd like to go ahead and ask a question, which is, Stephen, do you have or would you be interested in making a prediction on what we're likely to see with corporate liability under the ATS?
Oh, that's a really interesting question. You know, the issue here with respect to corporate liability comes out of a number of cases in which corporations were accused of having, in effect, joint ventured with international tortfeasors. The first big case like that was a case out of Burma called Doe v. Unocal, and it was in the Ninth Circuit. In Doe v. Unocal, the plaintiffs were Burmese villagers who claimed that their villages were burned down, and they were killed and raped and tortured and all sorts of awful things by SLORC, the then Burmese regime. But of course, they couldn't sue SLORC because it had sovereign immunity. So they sued SLORC's joint venture partner in this project to build a pipeline. And actually there were two joint venture partners. One was Total, which is a French company, so they were lost. But the other was Unocal, which is headquartered in Los Angeles. They filed suit in the Central District of California. And the courts dealt with that case in a number of preliminary rulings, holding finally that it would be sufficient to beat a motion to dismiss if the plaintiffs can allege and have some basis behind the allegation that it wasn't just that Unocal knew, but that they somehow had guilty knowledge. There was more than just being aware. It was actual, not participation in the torture, but some kind of complicity. And exactly where that line is to be drawn was going to be the subject of the trial. Well, the case settled. And so there was no trial, and therefore we missed the opportunity for guidance in that case. The next one, and one of the current ones now, is the Apartheid litigation that came out of South Africa, where plaintiffs claiming to have been victims of apartheid in various ways, again, couldn't sue the South African government, but sued American corporations that had invested in South Africa and that allegedly, according to the complaint, had not only aided and abetted the crimes of apartheid, but had benefited from them. That is, they benefited from being able to underpay black workers and from having the pass system and all that stuff. And that case went to the Supreme Court from the Second Circuit, only to have, for the first time in decades, the Supreme Court have to pass because 5 of the justices recused themselves because they were shareholders in the defendant companies, so there wasn't a quorum to hear the case. So the Second Circuit had remanded the case for trial. It now is in the trial court, and the Second Circuit on an interlocutory appeal has held that aiding and abetting is not a sufficient basis to get corporations held responsible for violations of international law. Very extreme. This is the same court, after all, that brought us not only Filartiga itself, but Karic v. Karadzic, which is the case involving rape as a weapon of war. So the Second Circuit has been the Alien Tort Statute plaintiff's best friend until now. So with that as prelude, what's the prediction? Well, I think if the composition of the court when that case is heard is precisely the same as it is today, I think that the plaintiffs, that is, those who would permit aiding and abetting liability, will win by a whisker. If, however, President Bachmann gets to appoint the next justice on the Supreme Court, I would not be so sure.
Great. Well, thank you very much to the panelists, and thank you very much to the audience for being here with us.